Our mediator has asked us to sort of briefly outline what's going on in our country, so I want to do that real quick with the United States. By default, or the default mechanism for resolving disputes in the United States is litigation, not surprisingly, I guess. We have a relatively efficient system. In other words, it takes about 2 years to get to a verdict, and that's without an appeal. The biggest driver, I think, for all of this, the parties want to do this part. The biggest driver for all of this is actually, I think, us attorneys. Okay, so in any event, I come to, as it was mentioned, I was a prosecutor for 12 and a half years. I come from a litigation background. I've tried thousands of cases. Not to blow my own horn, but I've won over 90% of them. And the reason I say that is not to blow my own horn, but to sort of put what I'm saying after this in context of where I come from, okay? The next system, next most sort of popular resolution system, of course, is arbitration. Federal Arbitration Act is a very simple 3-page document. It's been in effect since 1925. There's been like no changes. There's an international component, a domestic component. It works. It predates the UNCITRAL model law. It's been around. It's stable. There has been some changes lately. I should say changes and challenges in the area of consumer credit issues and employment labor issues as it relates to pre-dispute arbitration clauses. In other words, should people be subject to these clauses, maybe if they get a credit card and it's on there and they don't even read the boilerplate. So that's one area there's a little change there. Competence, in other words, the arbitrator determining his own jurisdiction is another area where there's some erosion, I think, or attempts to erode that. But overall, the United States is arbitration-friendly, member of the New York Convention. The least used dispute resolution system is mediation. That's changing a bit. Part of it as a result of courts mandating that parties go to mediation. There are some people who think you can't force parties to mediate. You can, and it works. Okay? And also, if it's in the private system, American Arbitration Association, folks like that will suggest that the parties go to mediation first, okay? So there is more and more mediation, I think, happening. Ultimately, 98% of cases settle, okay? So in reality, litigation is the alternative, okay? We have all this building up to it, but in the end, it's a very small percentage of how you resolve a dispute, at least in the United States. Sometimes you use all three, as was mentioned. You might mediate. That usually resolves about 80% of cases. Gone, out of the system. Arbitration, binding if you don't appeal to the court, will dispose of about 60, okay? But when you combine dispositive motions and settlement and things like that, only a couple percentage of cases actually go to court, and including many reasons such as the parties ultimately, after all the posturing, after all the tough talk, are afraid to lose, or they're afraid of the costs, or they've seen the light, as it were. Now let's go to my next slide here. Okay, so that's courts. That was that slide. I have one of those too. It's actually not mine, but it makes, I use it a lot when I'm mediating. I'm an arbitrator, and I'm a mediator, and I'm a litigator. This basically, to summarize, it shows that in terms of cost is lower. Risk, there's no risk in mediation. There's no risk in mediation. If you don't like the deal, you don't do it, right? Okay? And control, you have absolute control. Okay? Whereas litigation, less, well, I wonder if any attorney has ever said to their client, look, they come in and they got a dispute, say, look, we've got a way that's unpredictable, it's expensive, and it takes a long time. How about we do that? All right? Not happening, right? So, arbitration. With arbitration, I think the key, and it has been mentioned a little bit, this is time, okay? One of the things that we like to do as human beings is not have a lot of disputes in our life, okay? We like to resolve them, and we like to resolve them quickly. Our clients are no different, okay? And so the only sort of objective measure, because you can find surveys, and I'll quote a few surveys, but I'm not always a big fan of surveys. But one sort of way to look at it is eBay. Everybody's heard of eBay. They have a lot of sales, billions of sales, I think, a day. And they have a lot of disputes. And what eBay found in resolving their disputes, was get it done quickly. That even if people felt the process was fair and it was done quickly, they would return and do eBay again. They would either sell or buy on eBay. If the process took a long time, even the winners stopped using eBay or used eBay less. So I think that's what shows the importance of time. And they're smaller transactions generally, but the amount of the dispute was not a factor. Okay, there was no correlation. Simple disputes resolved quickly. People want their disputes resolved quickly. So there's many ways to compare and measure the results of litigation, arbitration, and mediation. For me, the most important is client satisfaction. Is my client happy with how things went? Okay? That's not fairness. That's not vindication. That's not making the other side rue the day they ever contracted with us. Okay? It's not even about justice. It's about taking your client from where they are today to a better place tomorrow. Okay? It's not about paybacks. I'm always sort of amazed at these people who come up with these great ideas and these great companies and these great innovations and how they know everything about their business but how to resolve their disputes. But let's say, we saw all those great pictures and the machines and things like that. Let's say it's an internal issue and the machine breaks. It doesn't work, okay? Now they have to resolve that. They have to resolve that problem. Are they going to do an adversarial process? Are they going to call conflicting experts to argue about it? Are they ultimately going to let some neutral person who may not, certainly has no interest in the outcome, doesn't have to live with the outcome to decide how to fix the machine? Would you ever do that to resolve a dispute? Do you feel confident that's the best way to get the right result? How to move forward, how to be better tomorrow than you were today? It's also really how they think, right? It's how they started their business. They saw a problem. They didn't adversarial fight about it. They came up with solutions. They came up with a way to fix it. So that sounds a lot like mediation to me. One of the advantages I guess I have, or disadvantages, is when you speak so late, is try to figure out what's going to be said already. And so everybody's sort of gone through mediation and arbitration and stuff like that, and I don't need to do that. So let's talk about when to mediate, okay? I used to think that the best thing to do If the parties could work it out, let them. Right? Let them negotiate, work it out. It's cheaper, if you will. Then I became a mediator. And what I found is when the parties try to do that, really, we end up with less options, we end up with less resources, we end up with more baggage, more obstacles. Okay? Some say that I was just reading, and actually preparing for this, that you should mediate when the parties stop communicating. Well, I suggest you get to that point, and you already have a lot of baggage in trying to resolve this case. Okay? Maybe it's as soon as there's a stalemate in the negotiations. It hasn't gotten emotional yet, it hasn't gotten a problem, but there's a stalemate. I will say this, and I've seen it plenty of times. One word can take a resolvable issue and make it an unresolvable issue. As human beings, we say talk is cheap. What I found in dispute resolution is that words are harder to forgive than actions. So I think you need to bring the mediator in sooner. As soon as you see a dispute. I might even go further than that, because I've seen it and I've seen it work. I've seen you see it a lot of times in negotiation, the initial negotiation, that people start to get on each other's nerves, right? And we're not totally honest, okay? We see issues and you don't want to really bring them up. You want the deal. So bringing in the mediator in the beginning, during the initial negotiation, consider it, in-house counsel and folks like that. You may not get a better deal, but you'll get a better relationship. You'll get a better understanding. As Bruce was saying, you have a contract and then things start breaking down and you have the architect over here and you have the builder over here and you have the subcontractor over here, and they're all over the place in what this contract means. There's the contract and the interpretation of the contract. And it's not just them, of course, it's the court, it's the arbitrator. Everybody else is interpreting the contract. So you may not get a better deal, but you'll get a better understanding. And you'll get a better way to resolve the disputes if things go wrong. Statistically, I will say that they're online. You can find them. I don't think you'll ever find any situation where people have come and said, I really liked being in litigation, okay? 80% of one particular survey, 80% of people said it preserves relationships. It can be very important, okay? And you don't know what the future is going to bring. It saves 90%, saves time and cost. I don't know what the other 10% are thinking, okay? Disputes, generally speaking, if you're a company, they should end, right? And it's better if they end today. All right? It's less expensive. It's less taking of your time, your energy, your resources. If they end today, and they can end today. There's not one dispute that's out there that you guys are dealing with that we couldn't sit down with the parties and maybe work out a deal. And maybe make the pie bigger, and maybe make it better, and maybe devote our resources to other things now. Okay? I flew over on Emirates Air. And at the end of the flight, they come up with the little happy faces, or the little faces. Say, how was your flight? I had happy face, great airline. The happiest of faces. It goes from sad, very sad, angry face to happy face.
I think the UAE Ministry of Happiness would be great.
Yes. If figure litigation or arbitration, how many people who lose at arbitration are hitting anything but this very sad, angry face? Okay, that's 50%, roughly, right? Then you have the nominal winners, the people who won, but then in the end, they spent so much time, energy, and everything, and it really wasn't a win. Add them into your side of keeping clients happy and satisfied. You might even have the big winner, or the winner, who now looks, in terms of process, they're happy they won, but in terms of process, were they really happy about the 2 years of their life, or their 10 years of their life, or whatever it is that they gave up for this? Are they happy about that as a process? Are they happy about sitting around waiting for the court, sitting in the waiting room? Are they happy about time out of their life to do things? So in terms of process, in terms of speed, in terms of getting it done, in terms of getting the happy face, my suggestion to you is that you give it, we all think we know to mediate, give it a chance if you don't, and go into mediation open, with an open mind and a willingness to resolve the matter, okay? There may be frivolous suits that doesn't apply to. There may be times when you're worried about the floodgates opening. I get all that. But if there's a good faith dispute, not, we've decided it's frivolous, but I mean, it really is frivolous. I mean, if there's a good faith dispute, look for the happy face, try to resolve the issue, and keep your client satisfied. Thank you.